Phones are off. Make sure, I hope you all signed in. If you have not signed in, do it quickly. When this hearing is over and this meeting is dismissed, make sure you sign out as well. At this point, Judge, if you're ready, I'm going to turn the venue over to you.
Thank you, Mr. Chairman. We have got one case on the docket this morning, members of the board. It's the Department of Commerce and Insurance, Division of Regulatory Boards versus Spencer Lindahl. The docket number is 12.18-135760A. Today is March the 10th of 2016, and I'm Mary Collier, the administrative judge assigned to preside over this hearing with you all. We have got the respondent who wants to participate by telephone. Do we have him plugged in yet, or how do we do that?
Have my jacket on, I get hot.
We didn't have a dress code this morning.
We're sorry. Your call cannot be completed as dialed.
Sorry.
Please check the number and try again, or call your...
Got sweaty palms today.
Right.
We're sorry. Your call cannot be completed as dialed.
Not dialing 9, are you?
I'm not. I'm not putting the 1 in front of it. I'll try the 1. I don't know if this one got updated.
On my phone that says don't dial 9. I mean,
Yeah.
you do that for 30 years, and it's like, how do I not dial 9?
Yeah, we did that at my office too. We don't have to dial that.
We're sorry. Your call cannot be completed as dialed. Please check the number and try again, or call your attendant to help you.
Try 9.
Do you have an attendant to call?
We just spoke with him. I can call the IT if this doesn't go through. Is 9.
Hello?
Hello, Mr. Lindahl.
Yes.
This is Jenica Smith, paralegal for the Tennessee Real Estate Commission. I will turn it over to Administrative Law Judge Mary Collier.
Thank you.
Thank you, Jenna. Mr. Lindahl, this is Judge Collier. Can you hear me?
I can. Can you hear me?
I can, and you are on the loudspeaker in our hearing room, and I have just called the docket, and your case is the only case on the docket, and we're about to have the board members introduce themselves. Go ahead.
Thank you.
Mr. Wood, say your names.
I'm Bobby Wood from Mount Juliet, Tennessee.
Marcia Franks, Franklin, Tennessee. Janet DeChara, Jackson, Tennessee.
John Grease from Knoxville.
Diane Hills, Kingsport. Fontaine Taylor, Memphis.
Johnny Horn, Chattanooga.
Thank you, members of the board. Members of the board, earlier, I want to say it was toward the end of last week, Mr. Chick for the state notified my office that Mr. Lindahl would like to participate by telephone this morning. Now, under our statute, that is a provision that can be allowed provided that the parties are in agreement, which, Mr. Chick, are you in agreement for Mr. Lindahl to participate by telephone?
Yes, ma'am.
And they have to have my approval and your approval. Mr. Lindahl, what is the reason that you wanted to participate by telephone today?
I'm an out-of-state non-resident broker.
We've got to get the speaker where we couldn't hear you there. Could you say that again, please?
I'm a non-resident real estate broker, so I do not live in the state of Tennessee.
Get the speaker working, Mr. Chick? Okay. Mr. Lindahl, I'm sorry. I could hear you in the background, but our speaker system was malfunctioning. Could you please state that one more time?
Yeah, I'm an out-of-state resident broker, and so I do not reside in the state.
And what is your address, please, sir?
The address is 575 West Chandler Boulevard in Chandler, Arizona, 85234.
Members of the board, under the statute which reads, in the discretion of the administrative judge or hearing officer and agency members and by agreement of the parties, all or part of the hearing may be conducted by telephone, television, or other electronic means if each participant in the hearing has an opportunity to participate in, to hear, and if technically feasible, to see the entire proceedings while taking place, which obviously we can't technically see Mr. Lindahl, but we can hear him now that they've fixed the speakers. And I will take a roll call vote to see if the board members are in agreement to have Mr. Lindahl participate in the hearing by telephone. Mr. Chairman?
Yes. You want me to do
If
the
I'll
roll
let
call?
you do the roll. You know, I don't know how to do that.
I'll let Mr. Young, will you just work left to right? And
Turn that microphone around to your mouth.
Okay, roll call. Bobby Wood,
Yes.
Marsha Franks,
Yes.
Janet DeChera,
Yes.
John Grease,
Yes.
Diane Hills,
Yes.
Fontaine Taylor,
Yes.
Johnny Horn.
Yes.
All right, Mr. Lindahl, the board has unanimously approved your request to participate in the hearing by telephone. So we will proceed with the hearing. As I said a moment ago, members of the board, I'm Mary Collier, and I'm the administrative judge assigned by the Secretary of State Administrative Procedures Division to preside over this hearing this morning, sitting with you all. And as I stated, we only have the one case on this morning's docket. During today's hearing, I will make all rulings regarding the order of proceedings, the admissibility of evidence, and any procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact, the conclusions of law, or the ultimate decision of this board. Those decisions will be made by the commission members at this time. We've already introduced ourselves, so don't do that again. We got out of order to get the phone call going. Mr. Chairman, is there a quorum of the commission present?
Yes, Your Honor.
All right, excellent. And Mr. Lindahl, you there? Do we have him still? Okay, Mr. Lindahl?
Mr. Lindell?
Jenica, does it look like the phone call's still running?
I'll call him again.
Okay.
Oh, can you hit answer? Hello?
Yeah, is this the Tennessee Real Estate Commission?
Yes, is this Mr. Lindahl?
Yes, I lost, somehow was dropped, so.
Well, we were trying to find you, so good. Do you recall what I was saying when you were dropped from the call?
When I was dropped just as you had approved to do it over the telephone.
Okay. Well, as I was saying a moment ago, I will make all rulings regarding the order of proceedings, the admissibility of evidence, and any procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact, the conclusions of law, or the ultimate decision of this commission. Those decisions will be made by the commission members. The chair did announce that we do have a quorum. We've already had Mr. Chick informally introduce himself. I'll let him introduce himself formally now.
Hi, Adrian Chick, Assistant General Counsel for the Department of Commerce and Insurance, Division of Regulatory Boards. Good morning.
Thank you. And Mr. Lindahl, you have the right to have an attorney with you, and I assume because no attorney has made an appearance in the pleadings in my office that you have chosen to proceed without an attorney. Is that correct?
Yes.
Thank you. Members of the commission, during the hearing, there should be no discussion of the case outside the board hearing itself. There should be no discussion between commission members and myself or witnesses, the attorneys or the respondent, or any other board or commission staff or any other person in the audience outside of the hearing itself. People must be sworn in for us to hear the testimony during the hearing. During the hearing, the commission sits like a jury and must only consider the evidence admitted during the hearing in reaching its decision. The Tennessee Open Meetings Act or Sunshine Law requires that all commission discussions and deliberations be in public before all parties. Failure to comply with the Tennessee Sunshine Law could result in the commission's action being reversed or remanded if the case is appealed to Chancery Court. Members of the board, during the hearing, any breaks that we should take during the hearing, you may not use any electronic device or media such as a smartphone, tablet, iPad, iPhone, other electronic device you might have in your pocket or purse, or any internet service or text messaging service to communicate any information to anyone or to receive any information from anyone or to conduct any research pertaining to this case. You should not, and you, of course, you could, if you have a text you need to get from a family member, you can get that. It just can't be related to the case. You should not draw any conclusions until all of the proof has been submitted. You should listen openly to all of the proof, regardless of which side submits it. At this time, I will go through the documents that are contained in the technical record. Mr. Chick, if you would like to pass a copy of the Notice of Hearing and Charges, which is the first document I have in the file, to the members of the board at this time, please do so. Members of the board, the first document I have is the Notice of Hearing and Charges, which Ms. Smith is now handing you a copy of. That was filed in my office on February the 3rd of 2016. The second document in the file is the pre-hearing order that Judge Cameron issued on February the 4th of 2016. She was the judge at that time assigned to this docket, but she picked up an out-of-town docket, so I picked up the docket for her. The third document in the file is a petitioner's notice of witnesses and exhibits, and that was filed on March the 3rd of 2016. And the fourth document in the record is the petitioner's amended notice of witnesses and exhibits, in which they changed the name of the director of the Real Estate Commission. And I believe that was the only change. Is that correct, Mr. Chick?
Yes, ma'am.
And that was filed in my office on March the 4th of 2016. And based upon that witness and exhibit list and the roll call vote, appears we have a new director, and I would like for him to introduce himself for the record as well.
I am Malcolm Young, the Executive Director for the Tennessee Real Estate Commission.
Thank you, Mr. Young, and nice to meet you. Ms. Chick, are there any other documents that I should have in the file that I have not identified?
No, Your Honor.
Right. And Mr. Lindahl, I did not see that you had sent any documents in. Are there any documents that you sent into my office that I did not receive?
No documents, nor did I receive documents from March 3rd.
So you've not received the notice of witnesses and exhibits?
No, I requested those from Adrian and have not received those.
And Mr. Chick, your certificate of service says you sent it to him by U.S. mail and electronically?
Yes, that's correct, Your Honor.
Are
you not receiving your emails, Mr. Lindahl?
I did not receive the email, and I did receive the mailed document. It was just there was no actual forms attached to it. The only thing I received was the document dated March 3rd, but no actual documents attached in the mail.
You mean no exhibits?
No exhibits.
Did you contact Mr. Chick to come to his office and review the exhibits? The exhibits don't have to be mailed to you.
No, I know, and that's why I emailed asking for them and did not receive that.
Chick, did you receive that email?
Your Honor, I received an email yesterday. In fact, yesterday, I believe I got an email from Your Honor about the hearing, and where Mr. Lindahl asked what time the hearing was, I replied to all on that and said 9 o'clock Central Standard Time. And
that was not the same email. That was a few days ago.
Okay, and I also sent the document, a copy of the exhibits that I was going to introduce to that same email address. So the same day that he requested it. So I can't explain why he didn't get those.
And do you have access to email at the moment, Mr. Lindahl?
I do.
Can you have someone on your staff send those to him? Again?
Let me look at my email here and see if I can resend it from my email. I'm showing the email here. Attached exhibits are what I plan to introduce tomorrow. I can word that. Okay, the email that I sent yesterday, it shows 3/9/16 2:44 p.m. Okay, and the address. Oh. Okay, and the address that comes up when I do Spencer is SLINDAHL at MSRENEWAL.com.
Yep, that's correct.
So you've resent that to him?
I've just resent that.
All right, Mr. Lindahl, you should get that shortly. Mr. Lindahl, I did not receive a notice of witnesses and exhibits from you. Did you plan to have any witnesses or produce any exhibits during today's hearing?
No, we gave all the exhibits that were evidence to Mr. Sheik, and so what he's provided is all that is pertinent to the case.
All right. Members of the board, the documents that I've just identified as being part of the technical record are entered into the technical record in this case. That includes the notice of hearing, which you were handed a copy of just a few moments ago. Should you need to review those documents during the proceedings, I will provide them to you. And of course, you have the copy of the notice of hearing. I would like to remind the attorneys and Mr. Lindahl that the documents that are contained in the technical record are not considered evidence unless and until they are admitted into evidence during the hearing. Having had a chance now to review the notice of hearing and charges, members of the commission, the law requires you to disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from any of the parties concerning this case. Does anyone have anything to disclose?
You do not.
All right, thank you. And Mr. Lindahl, I know you can't see us, but everyone shook their heads no.
Okay.
Before the hearing itself begins, I'm going to give you all some preliminary instructions to help you understand how the case will proceed, what your duties will be, and your conduct during the hearing. When I've completed these instructions, Mr. Chick and Mr. Lindahl will be given an opportunity to make their opening statements. Opening statements will be brief outlines of what Mr. Chick and Mr. Lindahl expect that the evidence will be during today's hearing. After the opening statements, you will hear the evidence itself. The evidence generally consists of the numbered exhibits and the testimony of the witnesses. Because the state has the burden of proof, the state will present its evidence first. The respondent will then be given the opportunity to present evidence. Although the evidence is presented by asking witnesses questions, the questions themselves are not considered evidence. During the course of the hearing, there will be an opportunity for each of you to question each witness who testifies under oath. Please use your questions as opportunities to gain any information or clarification of the facts that you would like to assist you in reaching a decision in this case. However, you should reserve any expression of opinion you may have until that portion of the hearing that is set aside for the Commission's deliberations, which occurs after all of the proof in this matter has been heard. During the hearing, objections may be made to evidence or trial procedures. I may sustain objections to questions asked without permitting a witness to answer, or I may instruct you to disregard an answer that has been given. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you are instructed to disregard. Often, arguments about objections or motions may require the attorney's oral arguments to be heard by myself sitting outside of the presence of the Commission. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from any of my rulings that I hold any view or opinion for or against either party in this hearing. When all of the evidence has been presented to you, the attorneys and self-represented party will make closing arguments. The attorneys and self-represented party will point out to you what they contend the evidence has shown, what inferences they think you should draw from the evidence, and what conclusions they think you should reach. The state will make the first closing argument, followed by the respondent's closing argument. Statements and arguments made by the attorneys or self-represented party are not considered evidence except for the testimony that Mr. Lindahl may present to you. Attorney statements are made only to help you understand the evidence and to apply the law to the evidence in the case and to persuade you of that party's position in this case. You should ignore any statements by counsel or argument that's not supported by testimony by the self-represented party in this matter. Pursuant to the Uniform Rules for Hearing Contested Cases, the State Department has the burden of proof in this matter. The state must meet its burden of proof by a preponderance of the evidence, which means that that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by the preponderance of the evidence, a party must convince you that the allegation is more likely true than not. If the evidence on a particular issue is equally balanced, that issue has not been proven by a preponderance of the evidence, and the party having the burden of proving that issue has failed to meet its burden of proof. You must limit your inquiry regarding violations of statutes and rules to those violations that are alleged in the state's notice of charges in this case. If you believe the respondent's acts have violated a statute or rule that has not been alleged in the notice of charges, you may not inquire into or address those violations. Because the state is the party with the burden of proof, it is the state's burden to establish all of the facts necessary to prove every violation alleged. The respondent does not have to prove that he is innocent of the charges. After closing arguments are made, I will further instruct you on the rules of law that apply to this case and the structure of your order. It is your function, members of the Commission, to determine what the facts are, to apply the rules of law that I give you to those facts, and to make conclusions of law in which you decide whether or not the respondent has violated certain rules of the Tennessee Commission of Real Estate or the Tennessee Code. And if such violations have occurred, what the proper discipline is or what the proper action is, if any, that should be taken against the respondent. The Commission will then need to state a policy reason for the decision. As the sole judges of the facts, members of the Commission must determine which of the witnesses' testimony you accept, what weight you will attach to it, and what inferences you will draw from it. The law does not require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which testimony you believe and how important you think that witness's testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of a person's testimony. In deciding which testimony you believe, you may rely on your own common sense and experience. This time, I don't believe there are any preliminary motions. I didn't see any in the file, were there, Mr. Chick?
I don't have any, Your Honor.
All right, at this time, we'll start with opening statements. Mr. Chick.
Okay, it's just very briefly, ladies and gentlemen of the commission, this is a case where the petitioner of the state intends to demonstrate that the respondent is a licensee of the commission, a principal broker. He was at the time of these events, and I believe continues to be. And that around May of 2015, Mr. Lindahl had some acquisition assistants working under his supervision, and these assistants sent emails relaying, offering to increase offers and counter offers and so forth. And then, in fact, the work of these assistants was conduct that constitutes brokering, that they weren't licensed. So the allegation is that he employed or used unlicensed people to do brokering work. And the state will also show that a copy of the complaint was sent to the respondent by certified mail at the last known business address, which by statute, that's where they're required to be sent. And that it was delivered. We got our green card back. It was delivered. There was no response. So that is the second violation. And I'll leave it at that.
Thank you, Mr. Chick. Mr. Lindahl, I'm going to go ahead and swear you in before you present your opening statement in case you present factual information in your opening. Would you please raise your right hand?
Okay.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your complete name, sir.
Spencer James Lindahl.
Thank you. Would you like to make an opening statement, which is merely a statement of the issue that you would like for the board to consider today? You will have a chance to present testimony later in the hearing, so this is just mainly an overview of your position.
Yes, I would like to.
Go ahead.
I appreciate the opportunity to speak today and have the opportunity to have my voice heard in this case. With regards to the case, we feel like as the principal broker for Main Street Renewal, that we have 3 points to prove today. One is that we were served, but we were not served at the notice of non-resident applicant consent to suit that was filed with the state of Tennessee at time of application. And so that notice was never received by our office in Chandler, Arizona, which is where we asked to be have all suits and actions presented. We did finally get the second notice that was served to our Memphis office. The second point I'd like to point out that the original emails that were sent represented who my assistants were, and their non-licensed agency was disclosed at that time and point. And the third was that we would like to discuss and bring up today is that while we are, while there was an email that was sent out that was sequential to the original offer and agency representation that was submitted, we asked, that was not part of the traditional process or best practices of our business. And so those are the 3 things that we would like to point out today.
Thank you, Mr. Lindahl. Mr. Chick, who would the state like to call as the state's first witness?
Mr. Malcolm Young.
Mr. Young, if you'll come up to the stand over there, please, sir. In chair on the end. That's all right. And if you'll move the mic down so we can all hear you. Please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, and please state your full name for the record.
Malcolm Young.
Thank you. Go ahead, Mr. Chick.
Good morning, Mr. Young. Will you state your position with the department?
I'm the Executive Director of the Tennessee Real Estate Commission.
And how long have you been here?
1 month, 10 days.
Okay. What are some of the main duties that you have as the executive director?
Uh, we process complaints. We receive complaints. We we also approve education courses. We also grant licenses, and we also revoke licenses as well.
Would you consider yourself to be the record keeper for the commission records?
Yes.
Can you tell us, just briefly explain what the process is when a complaint is received against a licensee?
When we receive a complaint, we review it. It is also reviewed by we have a staff person assigned to those complaints. After it's reviewed, it's opened and it's placed in our online system, and then it's also forwarded to the legal department as well for their review and investigation. And then it's also sent out to the respondent to also receive the respondent's comments on the allegations.
I'd like to show you something, and this is going to be a document that I've labeled in the lower left-hand corner as 2015-7-31 notice of complaint.pdf. You got that, Mr. Lindell?
Your email with documents has not come through yet, so I do not have that. But you can describe it to me if you would, Mr. Sheik.
Okay, well, let me let the witness see if he can describe that. Can you tell us what that document is?
This is actually our standardized documentation that we use to notice the respondents with the attached complaint in the complaint form that is sent to the respondent for response.
What's the date on that?
The date is July 31st, 2015.
Is that a standard record that's maintained?
Yes, that would also be entered into our system.
The state would like to make that Exhibit 1.
The document Mr. Young has just described will be marked and entered into evidence as Exhibit number 1, and you may pass copies to the board.
Hey, Mr. Young, you said that a copy of the complaint was sent out in a notice. Is this what you're referring to?
Yes.
And
It's also sent out by certified mail.
okay. Now, as far as the address, what address is there a certain address that these have to be sent to?
Yes, it was the business address, which is 5050 Poplar Avenue, Suite 1430, Memphis, Tennessee, 38157.
And if you'll look on page 7 of that document, actually you have to look on page 7 along with page 8, and based on those last pages, can you tell whether or not this document was delivered to that
It
address?
was delivered because obviously the green card was signed for and returned to our attention.
Mr. Young, I'd like to show you now a document. It's in the lower left-hand corner. I've identified it as 2016-03-08 RBS PDF. And see if you can recognize that.
These are actually our records that are maintained on our computer-based system to track the licensees.
Your Honor, I'd like to make that exhibit number 2, please.
You'll pass that up, please. This is a computer database printout.
Yes, ma'am.
All right, this one-page document that has just been handed to me as the computer database printout from the C&I Regulatory Board system will be marked and entered into evidence as exhibit number 2. Ms. Smith, you may pass copies to the board.
Hey, Mr. Young, your this RBS system.
Hold on. You gotta let the court reporter finish marking. Go ahead.
Mr. Young, has there been some kind of update to the way the state maintains records that you're aware of?
Yes, sir. And this is the this is when Mr. Lindahl actually became a licensee, which was an RS system, and then we have also switched over to a new database called Core.
Okay, so at the time that around May of 2015 is this RBS system the system that was in place?
Yes.
Okay. And based on this, can you tell us what the last known business address of Mr. Lindahl is?
The business address that we have on the RS system was 5050 Poplar Avenue, Memphis, Tennessee.
Okay, now I'd like you to look at a document that I've identified as 2015-09-20 2000 email.pdf.
Okay.
And tell me if you can recognize that.
I do recognize it. And
is that part of your records?
It is. I mean, it's the email address.
Is this document something that that's maintained in your complaint records?
It would have been submitted to the complaint records.
Okay. Your Honor, I'd like to make that the next exhibit.
What are we calling this document?
I'm calling it the 2015-09-20 2000 email. I try to label it by the year and then the time it was sent. So.
All right. If you will pass that up, that email PDF will be marked and entered into evidence as exhibit number 3. I pass copies to the board.
And I would like to show you a document named 2015-09-20 2002 email. And tell me if that's a document that was made part of your records.
Yes, sir, it was, because it's part of the complaint file.
And I'd like to make that number 4, please.
All right, the second email PDF that you've just handed to Mr. Young will be marked and entered into evidence as exhibit number 4. Hand me the copy as well as pass copies to the board, please.
Judge, is there any way to get copies of these? I still do not have any copies of anything that's going on.
Mr. Lindahl, obviously because you chose to participate in the hearing by telephone, I can't hand you copies of what's being handed to the board. You should have confirmed that you had received this prior to this morning. Mr. Chick has tried to send it to you again this morning. We will take a 5-minute break and he can try to send it to you again. But again, since you're not here, I can't physically hand you anything. Members of the board, during the break, you may review the 4 exhibits that you've been handed. I know some of them are lengthy, so you may go ahead and read those. You may not discuss them amongst yourselves or with anyone during the break. You also may simply take a break if you'd like to. Mr. Chick, if you and Mr. Lindahl will go off the record and let you all take an opportunity to figure out how to get his email where it works. And I know you can't fix his email. You know, Mr. Lindahl, you may need to get some tech support at your end so you're receiving the emails. We'll go off the record for the next 5 minutes.
This is Spencer.
Mr. Lindell?
Yes.
Excellent. We are going to go back on the record. Mr. Chick and Mr. Lindell, did you all work out the exhibit issue?
Yes, I got them.
Okay. Let me ask Mr. Lindahl, would he stipulate to the remaining 2 exhibits? Or
Yeah, all those exhibits I'd stipulate to be evidence.
okay.
All right. Go ahead, Mr. Chick.
Okay, so Your Honor, I guess I need to mark these 2.
We stopped, the last exhibit that was entered was exhibit 4.
Well, let me give court reporter a copy, let her mark on it.
All right, so the document that has October the 9th, 2015 at the top, it's a letter to Mr. Lindahl from the State of Tennessee Department of Commerce and Insurance by stipulation has been marked and entered into evidence as exhibit number 5. You may pass copies to the board.
And then the last exhibit is Mr. Lindahl's response.
Hey, we can't hear you, Mr. Chick, when you're wandering the room. Can you say that again so I know
Last
Mr.
exhibit,
Lindahl
Your
can hear
Honor,
you?
is the response from the respondent.
All right, the response from the respondent dated October 28th of 2015 will be marked and entered into evidence as exhibit number 6, and you may pass copies to the board.
Thank you. Okay, Mr. Young, I just want to ask you to read over one of the emails, and that would be exhibit number 4. That's the 2015-09 2002 email.
Is this between Ms. Kirby and Mr. Harper?
What I want you to look at is the original message down there that begins with "Hi, Robert."
Yes, after receiving your client's rejection, the buyers wish to raise their offer to $124,500. Please let us know if that is something your client could work with. Thanks, Kim Timpano.
Okay, and is that the communication that supports the employment or compensation of unlicensed persons?
Under the statutes?
Yes, is that what's the basis for the charges?
Well, the basis of the charges is unlicensed activity.
Is Ms. Kim Timpano, is that the unlicensed person doing the unlicensed activity, as you understand?
I would assume so.
Okay.
Just also looking at the title.
All right. Your Honor, that's the state's proof. Rather than reading these things out loud, I would just ask the board to give them a few minutes to read all the exhibits, especially number 6. And
All right, members of the board, I know we had the break a few minutes ago while they were working out the exhibit issues, so I think some of you have started reading the exhibits, but we will take a moment or two now before we have a chance for cross-examination for you all to read the exhibits.
Your Honor, may I make one observation? As far as in time, had the sequential event in time actually just want the board to notice that actually number 3. Oh, they're right. Okay, number 3 email happens before 4. Okay, never mind.
Members of the board, have you all had a chance to read these 6 exhibits? All right, Mr. Lindahl, do you have any questions for Mr. Young?
With regards to the state of Tennessee, Mr. Young, are you aware of the document that was submitted with my original license application, that is the Tennessee non-resident application consent to suits form?
The only documents that I'm aware of that we have are the official documents, which are the ones that are on the computerized system of the RS system that were entered as an exhibit.
Okay. Judge,
Again, Mr. Lindahl, you may testify later. This is an opportunity for you to ask Mr. Young questions.
Okay. So he's unaware of that document. That's all I need to know. Thank you.
Members of the board, do you all have any questions for Mr. Young?
I do. Mr. Young, on exhibit number 2, There is 2 addresses at the bottom of that form.
Yes, ma'am.
What are the 2 different addresses for?
HM stands for home, and ML is the main address, which would be the office address. The main address being 5050 Popular Avenue.
Okay, but on the line above that, it says the address we has for the firm is 2657 Appling Road, Suite 102, Memphis, Tennessee.
Yes, ma'am.
What does that apply to?
That would be the last known address that we would have record of.
But all the notices were sent to the 5050 Poplar Avenue.
Correct.
Okay, thank you.
Other questions?
I'd like to ask, what is the name of the firm on the on the same piece of paper on the Exhibit 2? His principal broker. Where does it tell me the name of his company? Did not have that on here.
It does not. It's not on here.
Okay.
All right, Mr. Young, I've got 2 questions for you. Exhibit 4. At the bottom of that, there's a person's name is Alicia Werkheiser.
Which page you on?
Up on the front page, number 1 of Exhibit 4. Alicia Werkheiser. Can you tell me whether or not that person is licensed for the state of Tennessee Real Estate Commission?
That's Exhibit 3.
3. Well, no wonder I can't keep track of this. Oh, I got that right. I'm sorry, Mr. Lindahl. Exhibit 3, the front page of Exhibit 3.
My knowledge, she's
not.
I thank you, Mr. Young. And then on what is now my Exhibit 4, the front page, there's a person listed as Kim Timpano. Do you know if she's licensed with the state of Tennessee?
She is not licensed with the state of Tennessee.
Thank you. The questions for Mr. Young?
I have one more. Mr. Young, so if Miss Werkheiser and Miss Timpano are not licensed with the state of Tennessee, are they allowed to send, according to the law of Tennessee, real estate law, are they allowed to send out these emails that they have sent out? Where are their offers and
I know that as far this would be considered an unlicensed activity.
I think the better question is to rephrase that question is, can an unlicensed person negotiate a contract?
Not under the Tennessee law.
Okay.
Other questions? Thank you, Your Honor.
Thank you, members of the board. Mr. Chick, do you have any other questions for Mr. Young?
Yes, Your Honor, I've got one redirect. Mr. Young, I just wanted to clarify when you were asked about Exhibit 2 down at the bottom, that Appling Road address, is that not for 12/9/2014?
Yes, it is.
Okay. All right. That's all the questions that I have, Mr. Young.
Thank you. Mr. Lindahl, do you have any other questions for Mr. Young?
Yeah, Mr. Young, on the Tennessee Board of Realtors website, there's a section that says what may an unlicensed employee, assistant, or secretary do. Are you aware of that section?
I object to that, Your Honor. There's no.
Texas overruled. He's the executive director, and it's the website for the entity he's the executive director for.
Oh, he's asked about the Tennessee Realtor. I'm sorry, can he clarify?
No, not realtor, real estate department.
Oh, okay. All right.
Yes, we have rules and regs on that website.
Okay. On there, are you aware of the section that says that these unlicensed employees, assistants, or secretaries are not allowed to send emails or communicate on behalf of a principal broker?
I'm aware of the website and the information on the website with the rules and regs.
Are they allowed? Are unlicensed employees allowed to email documents?
It depends on what activity that they're doing.
So are they allowed to email an offer document?
I would say that would be good, considering making an offer.
Even though the website says that they're allowed to do that, where it says on the unlicensed assistant?
I don't have that rule in front of me.
It was actually attached, Mr. Sheik, to what you have on the exhibit 2015-10-28. Attached to that exhibit, you omitted the document that I included behind that.
Which exhibit are we talking about, Mr. Lindahl?
2015-10-28.
Exhibit number 6?
Yes.
You're saying you had an attachment to your one-page October 28th, 2015 response?
There was an attachment to that, which was from the department's website, showing that what I'm speaking to, that unlicensed employees, assistants, or secretaries are allowed to deliver documents. And they're allowed to disclose the current sales status of properties.
The exhibit number 6 makes no mention of an attachment. So what is it you're saying was attached?
The unlicensed assistant's duties on the state of Tennessee's website. It's the second paragraph, the first sentence. That's what was attached to the back of that exhibit.
Ron, he might be referring to some frequently asked questions. Those are also in this handbook. So if he could tell me what number that is, maybe I could.
In the rules?
It's in the very front of this handbook here.
Handbook.
This one. Roman numeral 6.
Not in the. It's in the old one. I mean, what number it is?
What number are you looking at, Mr.
It's
Lindahl?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The 15th Romanette, but they're really not numbered on what I have. It says it to deliver documents and pick up keys, and then the 18th one is disclose current sales status.
Where are you looking, Mr. Chick?
The old law manual that they has it.
What page?
It's in the very front of the book. Roman numeral 6.
There's also that has to type contracts and forms for approval by principal brokers, assemble documents for closings.
Well, Your Honor, I'll be glad to stipulate if I can look it up here and pull it up. I'll be glad to stipulate that the commission's website says or doesn't say something, but Mr. Young can't make a legal conclusion. I don't think.
Do we have a way for the board to see the website?
I don't think so.
iPad or one of those mechanisms?
we can't connect to the internet via the iPads of the state. So
We have a laptop that'll connect. They can bring down.
Well, Your Honor, I think he's at the frequently asked questions that he is referring to on the website. They're the same thing that's in this green book. Would that help? And if so, we could just refer to what's in the green book.
Okay. Is there a way y'all can make a copy of what's in the green book, or
We
someone?
have, we
Or,
have them.
I know, but it's
Oh,
not
I'm
going to be in
sorry.
the record just because you're holding it. Can you make a copy of those pages, or can someone go upstairs and print out a copy of whatever it is Mr. Lindahl is looking at on the website?
Okay. Yes, ma'am. Jennifer's going to go upstairs and print out that website.
That page of the website. Thank you, Ms. Smith. If you make a lot of copies, that'd be handy. Okay, so Mr. Lindahl, what is your question for Mr. Young?
Does he feel, Mr. Young, do you feel that unlicensed assistants can deliver offered documents and disclose status of the properties?
I'm going to object to that, Your Honor. Again, he's asking for how he feels. That's not. He's asking for a legal conclusion from the director. I mean, he can ask him what the statutes say or rules, but
Asking him how he feels is not
Okay.
an appropriate question, so I'm going to sustain the objection. You may rephrase the question, Mr. Lindahl.
Thank you. Mr. Young, are you aware of the law with regards to unlicensed employees, assistants, and secretaries and their ability to deliver documents and disclose current sales status as per the statute of Tennessee?
Yes.
Do you represent that these emails are anything more than delivering documents that they were requested to deliver by a principal broker?
Your Honor, I would ask if we could object to that's kind of confusing, that question.
You could identify which email in particular you're talking about, Mr. Lindell. Your question was
Both
a bit
exhibits.
broader, I believe, than the testimony we've had so far.
Both exhibits, I believe the number is 2015-920, 2000, and 2002. Both the emails that were from Miss Kim Tapano and Elisa.
I'd ask you to ask one question about one exhibit and then move to the second exhibit, as opposed to a global question.
Okay. Mr. Young, on the exhibit 2015-920, 2002, where Miss Kim Tapano is delivering and her property acquisition assistant for Spencer Lindahl is delivering a document on behalf of me, do you believe, or is it your understanding that that is against the statutes that are represented of delivering documents and that these unlicensed assistants can do that?
I believe he's looking at exhibit number 4, members of the board.
To me, it looks to me that it's extending an offer.
The question is, do you feel that they are
And
not
again,
feel?
the objection has been sustained. You cannot ask Mr. Young how he feels. His feelings are irrelevant to these proceedings.
Does this email, other than delivering documents to Mr. Harper, who is aware of the original offer, and that I was in the agency and I have the agency with Mr. Harper and with my client?
I'm going to object, Your Honor. There's about 4 or 5 assumed facts that I've in that question so far.
Again, Mr. Lindahl, you will be allowed to testify later. You may not
Okay.
testify in the form of your questions for Mr. Young.
Okay. Thank you. One last question. With regards to consent of service, is there, I don't know how to frame my question, so I'll stop.
Thank you, Mr. Lindahl.
That's all I have.
Members of the board, do you all have any other questions for Mr. Young? And Mr. Chick, do you have any other questions for Mr. Young?
No, Your Honor.
All right, Mr. Young, we're going to let you step down for the moment, but when Ms. Smith gets back with the printout of the website where we can all see what it is Mr. Lindahl's looking at, I will let you be recalled so we can hear that testimony. Mr. Chick, any other witnesses from the state?
No, Your Honor, that's it.
All right, Mr. Lindahl, at this time, the burden of proof is shifted to you for your presentation of your case. Do you have any testimony or that you would like to present?
Yes,
All right, and you were previously sworn in and you were still under oath.
thank you. With regards to the original consent to service that we received at our Poplar address on July 31st, 2015, the statute of 6213.
Your Honor, excuse me, I'm going to object to that, best evidence grounds. If he wanted to refer to that document, he should have included that as an exhibit, and it's not, so.
What document are you talking about, Mr. Lindahl?
Exhibit 6, I believe. The exhibits I got were unnumbered, so I apologize. 2015-10-28. And the...
That is exhibit number 6?
Yeah, and then your consent to service, which is the 2015-731. That's the document I'm referring to.
That's exhibit number 1?
Yes.
All right, go ahead. Objections overruled.
Your Honor, I don't see that document in there, Your Honor.
What document?
He mentioned a consent to suit.
What consent to
Consent
suit
to
document
service.
are you talking about, Mr. Lindahl? I thought you said it was exhibit number 1.
Yeah, with exhibit number 1. So, okay. So in exhibit number 1, we did not receive, as per the statute on 6213-314, reciprocal license service to process of non-residents. We were not served at our non-resident address. And that's what I'm trying to point out in my testimony, that the original service went to our business address, which was not the address that the state of Tennessee had for my non-resident applicant consent to suit.
So tell us, what's a non-resident applicant consent to suit?
And I sent this to Attorney Sheik a few weeks ago. I don't know why it wasn't presented as evidence today. It probably should have, but he has this document. But it's on exhibit.
He's not required to present your exhibits. He's required to put on his proof. Is there a document that you wanted presented that you didn't notify us of?
Yes.
Again, as I said at the beginning, you did not file a witness and exhibit list with my office, so I have no information about exhibits that you plan to produce today.
And I apologize for that because I didn't get the exhibits. I assumed that the attorney would present all facts and not what was convenient
He
to
is
the
not
state.
required to present your case, Mr. Lindahl. What exhibit is it that you wanted presented that you did not file a witness and exhibit list regarding?
It's called the Tennessee Non-Resident Applicant Consent to Suits Form.
Mr. Chick, do you have such a form?
Your Honor, I don't have that. I do know what he's talking about, but I didn't include that. I didn't feel that's relevant to the case, and I didn't include that.
And what that form is, Judge, is, as you can see from exhibit, I believe, number 2, which is 2016-3-8 RBS. It's the address that's there highlighted with the black of 575 West Chandler Boulevard, which is my out-of-state address.
It's listed here as your home address.
Yes, that's the out-of-state address. And as the statute 62-13-314 with the state of Tennessee, a non-resident application need not maintain a place of business within the state, but if they serve this form, this Tennessee non-resident consent to suit with an out-of-state address where all actions and suits are supposed to be notified. So I did not receive the July 31st notice to me personally or my business as per the statute. And had I had received it at that time, I would have responded to the state immediately. But I did not receive that notice. I also provided to Mr. Sheik, which I know I'm doing a really poor job here representing my case, but I showed him where that employee that signed for Exhibit 1 was terminated shortly after for them not completing their duties. That was provided to Mr. Sheik. And I apologize, I'm talking about a bunch of documents that you don't have because I'm an idiot and don't know how this works. This is the first time I've ever been in any of these type of proceedings. And so all I'm asking for is that for the state to understand that we are not operating here to harm the public or the consumer. Mr. Harper was very aware that I was representing the buyer in this transaction. And when we made a second counteroffer to his declination of our first offer, which is Exhibit 4, Ms. Capano did not do the correct email language, but she was delivering a counteroffer which was already represented as me being the agent and representative of the buyer. So those are my 2 points, is that I wasn't served at the address that the state was notified to serve me to, and that the second email went out, and Mr. Harper, who was not the public, he's a licensed agent just like I am, was not harmed, nor was any consumer harmed. And they were very aware of the representation in this transaction, Mr. Harper was, because the first email went out stating that she was my assistant for me, I was the one presenting the offer, and Mr. Harper was very aware of that. I had conversations with him over the phone, and so that's all I have to say, Judge. I appreciate the time today.
Thank you, Mr. Lindahl. Mr. Chick, do you have questions for Mr. Lindahl?
No, Your Honor.
Members of the board, do you all have questions for Mr. Lindahl?
Mr. Wood.
Yes, Mr. Lindahl, if I were to go to the 5050 Poplar Avenue, is that an office or what is that?
Yes, it's an office.
Okay. Is that an office for the real estate company?
It's an office for our real estate company, and we operate our property management business there at that address.
Okay. So do you have residential sales or something at a different address?
We do not do residential sales in the state of Tennessee. We operate our acquisition business in Chandler, Arizona, where I reside. And then we have our property management business there, we have an office there in Memphis and an office in Nashville, where we do the property management, which is the leasing of the properties that we acquire.
Okay. But isn't this whole discussion over a residential property being bought?
Yes, we act as a buyer's agent.
That would be residential sales, wouldn't it?
I stand corrected. In the other states where I am more familiar is you have buyer's agents and seller's agents, and so we actually don't operate as seller's agent. We operate as a buyer's agent. Just so
okay.
I wasn't trying to be.
We're fine. Okay, and at that Memphis office, is there a broker there?
There is not a broker at the Memphis office. I travel there 2 or 3 times per month.
Okay, so who's registered with the state as the broker there?
Of that office in Memphis, I am.
Okay. Okay.
Come back to you.
Yeah.
Commissioner Horn.
It's, I have two questions. Excuse me, can you hear? One of the questions is, and it seems like you're putting a lot of weight on who served the notice or who wrote you the letter or the email. Does that really make a difference? Or, I mean, are you notified more or less depending on who notified you? And second of all, the address that it was sent to, how does that make a difference? If you received the notice, then you received it. If you didn't, you did not. So if you could clear that up for me, I appreciate it.
Yeah, the reason I'm bringing that up is because the state, actually not the state, probably the commission, originally, the video that I saw of the first hearing where I was not present, the largest reason that they proceeded on this
Yeah,
case.
just, Your Honor, objection. I just want to caution responded that he's getting into something that the commission is not aware of right now. You know, he's talking about an anonymous thing, so he's talking about the anonymous presentation where it's initially presented to the board.
Okay,
so.
Mr. Lindahl, the anonymous presentation to the board to determine whether or not notices of charges will be filed is not part of this hearing.
Okay.
Yeah, I don't mind if he talks about it, but it might not be in his interest to talk about what the board previously did or didn't do.
I mean, that's the mechanism by which the board determines if they want to pursue a case, but they don't have your name or anything other than that, of that nature when they're doing that. So what is your point?
The point was one of the reasons why I'm bringing up where I was served and I did not receive the first notice. I'm just trying to answer his question.
Let me ask you this. Were you given notice of today's hearing?
Yes.
Okay. And do you know what the hearing is about?
Yes, the unlicensed activity.
Okay. All right. Miss, I can't see your name.
Horn. Commissioner Horn.
Mr. Horn, do you have any other questions for Mr. Lindahl? All right. Other members of the board.
Ms. Franks.
Mr. Lindahl, on the purchase and sale agreement, which is Exhibit 3, at the bottom, your name is on there on the TAR form. So are you a member of the Memphis board?
I am.
Okay. On Exhibits 3 and 4 that were sent by 2 assistants, I find nowhere on here that they asked that the response go to you rather than them, which would constitute them being the ones who are negotiating this. And you have said, and you've acknowledged in your letter that you apologize that this has happened. Did you provide a copy of your employee guide best practices to the state?
I did.
We have a copy
And just to
of
answer
that?
your question on the email, the email that Ms. Tapano and Elisa sent their emails from was from my email. So the Nashville and the Memphis at MS Renewal, those are my email boxes that I manage and watch.
Okay, but they didn't ask Mr. Harper to contact you, did they?
I'm just pulling up the first email.
Okay.
Yeah, they do. They say right there in the first email, Miss Elisa asks the last sentence, please confirm receipt of this email. If you have any questions, please feel free to email Spencer Lindahl.
Okay, yes, I see that now.
That's on exhibit number 3, members of
On
the
number
board.
3. And on Exhibit 4, it doesn't say that though, right?
Correct, because Mr. Harper already had been communicating back and forth with me.
But he's not communicating. This is a communication from Kim Timpano.
From the same email box that came from Miss Alyssa, which is my email.
And signed by who?
It's signed by me, saying that she's my acquisition assistant.
It says Kim Timpano. Thanks, Kim Timpano, Property Acquisition Assistant for Spencer Lindahl.
Yes.
Okay, so she signed it, not you. Is that correct?
The email signature is, yes, it says Kim Timpano, Property Assistant for Spencer Lindahl.
Okay, so in nowhere on that email does it ask that Mr. Harper contact you about the offer.
You are correct. It's the same offer, that it's the same property, the same house, and so Mr. Harper was already aware of that.
Okay, I think that's all I have.
Other commissioners, Ms. Hills.
Mr. Lindahl, your Memphis address, business address, are you the broker responsible for that address?
I am.
So you have a firm address for selling real estate and a firm and a firm address for property management there?
Yes.
Your email address that you referenced it says Nashville on, for example, Exhibit 3 and Exhibit 4. Do you have an office in Nashville?
I do have an office in Nashville.
Do you have an office are you the broker of the office in Nashville?
I am not the broker in Nashville.
Do you have any other offices? Your company have any other offices in Tennessee?
We do not.
Okay. For the references, an example, Exhibit 3 and 4, it will say Property Acquisition Assistant for Spencer Lindahl. How many acquisition assistants do you have?
Currently, I have 18.
And are they licensed as a realtor in any state?
Some of them are, just depending on the state statutes and laws that we operate in.
To your point that you made on referencing a number 15 that says that unlicensed assistant may deliver documents, if you look further down when it talks about unlicensed assistants, do you see a number 4?
I don't have, they're not numbered, but if you could tell me what it says.
It begins, discuss or explain listings, offers, contracts, or other similar matters with persons outside of the firm. And the next one says negotiate any terms of a real estate transaction.
Yes, I see those.
Hold on one second. Ms. Smith, do you have a copy of this that you can give to everyone? Okay, I'm going to go ahead and we had the paralegal go upstairs and make those copies while you were talking with with Mr. Young. And we're going to mark and enter this as exhibit number 7? 7? Are there 2 of them? Okay. There'll be exhibit number 7 and exhibit number 8. And this is printouts. Ms. Smith, could you raise your right hand, please? Do you swear to affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. May I take a seat?
No, you can stay right here. Please state your full name.
Jenica Smith.
All right, could you explain to the board what you've made printed copies of, please?
This is the frequently asked questions from the Tennessee.gov website. You'll see the web address at the bottom, the TDCI help. So they come from the help desk. And there are 2 articles here. What may an unlicensed employee, assistant, or secretary do? I believe that's the
First document, yes.
Exhibit 7.
That'll be Exhibit 7.
Okay, and the second one is what can't an unlicensed employee, assistant, or secretary do?
All right, and that what can't list will be marked and entered as Exhibit number 8. And do you see both of those on the website, Mr. Lindahl?
I do, yes.
All right, Ms. Smith, before we go with more questions, I'll let you pass those 2 documents to the board. Thank you, Ms. Smith. Ms. Hill, I'll go back to you now for you, I believe, had a question
Yes.
about what's contained on Exhibit number 8.
So, Mr. Lindell, you see the 2 statements that I've read on these exhibits?
I do.
Okay. In exhibit number 4, is there an attachment of a written counter offer or offer that I'm missing?
There, I would assume, yeah. You're talking about Ms. Tapano's email. There was a document attached to that was an offer, counter offer to the property.
On the email I'm seeing, I see where there's no attachments marked or representing. It reads, after receiving your client's rejection, the buyers wish to raise their offer to $124,500. Please let us know if this is something your client could work with. Do you have a written counter, or was this the?
No, we have a written counter that we have. That was provided to the state.
I don't see it. Usually on an email, when you email something, there's usually an attachment symbol. And I don't see it referenced, see attached or anything like that. That's all for me, Judge.
Thank you. Other questions from the board?
Mr. Chara.
I have one. Mr. Lindell, on that same exhibit, number 4, you do note that at the top of this page where Mr. Harper is saying that he has received this email from Miss Timpano doing the work of a real estate agent, although unlicensed in Tennessee. So he obviously felt that she was the one he was dealing with. Would you agree to that?
That's his opinion. He received an offer from my email, from my acquisition assistant, but she did not discuss, explain the contract or similar matters. She did not negotiate any terms of the real estate contract. She delivered a document.
No, sir. If you look at that same email I'm talking about, at the bottom of the page, her response to him was, after receiving your client's rejection, the buyers wish to raise their offer to $124,500. Please let us know if that is something your client could work with.
If you look at Exhibit 6, I believe it was, ma'am, where I've already, in essence, told you that I agree with you in my response to the state.
Okay.
Okay, Mr. Lindahl, I have just a couple of quick questions. It seemed to me in your testimony that you indicated you thought there was a statutory requirement for the state to notify you at your out-of-state address. Was that your testimony?
Yes.
Can you prove that to me? I mean, if that's the case, I think you've got a good argument, but I don't have any evidence of that other than your statement.
Yeah, I have the rule in the official manual, and I have the form that I sent to the state and sent to Mr. Adrian Sheik. I do have those documents. I can read you the rule in the manual, the number.
What's the rule number, Mr. Lindahl?
So
what's the rule number?
62-13-314 4B1. And this is the form that's on your website of the Commerce and Insurance.
Okay, so
website.
that's a statutory site. Can you give that to me again?
It's 62-13-314. And that form that I'm referring to is in the forms and download section of the Tennessee Real Estate Commission.
Under 62-13-314, what particular subsection are you looking at?
The form at the state of Tennessee says subsection 4B1. And that's on the form that's on your website that's called the Tennessee Non-Resident Applicant Consent to Suits form. There's a PDF on your website. And that's the PDF that I submitted with my original application.
I don't think that says where that would be, what address.
I'm trying to figure out how to know what it says, Your Honor. Can he read it in the record, or
which one are we asking him to read?
He's quoting this section, but I don't know what it says. So, and then Ms. Frank says she doesn't think that's what it says, but I don't know. So
read us what it is you're reading, Mr. Lindahl.
Yeah, so it's
and tell us where you're reading it from.
Okay, so this is on the Tennessee Commerce and Insurance website on the form section for Tennessee Real Estate Commission. There's a PDF form that's called the Tennessee Non-Resident Applicant Consent to Suits form. And when I pull that form up, it says, I do hereby irrevocably consent that suits and actions may be commenced against me in a proper court of state of Tennessee as required by the official manual of the State of Tennessee Commission 62-13-314, sections 4B1. And it then asks for my out-of-state address, which you guys have record of in Exhibit, I believe, 2. Of the 575 West Chandler Boulevard address. And it says non-resident affiliate broker candidates only can do this. And it says the name of the firm, principal broker. And then it says that the applicant of the above named broker is not licensed in Tennessee. You're not eligible to be a non-resident license. And then it says mail all these forms in with my other course completions, copy of license, and all of that kind of stuff for broker approval to your Nashville 500 James Robertson Parkway.
You understand this is a licensure action, not a legal action in a Tennessee court of law.
Yeah, this is a form that the Tennessee License Division asked me to give them. And I'm answering the commissioner's
What I'm saying is,
question.
Do you understand that the proceeding today, this is not a Tennessee court of law governed by the judicial branch. This is an executive branch board action on your license.
And To me, I don't understand the difference, and I apologize.
And again, you did have the right to hire an attorney to represent you. I cannot give you legal advice, but the way I read 6213-314B1, that is discussing legal actions against you by the residents of the state of Tennessee, not a licensure action. Does that help you, Mr. Chairman?
Yes, thank you.
All right, any other questions by the board for Mr. Lindahl?
I have a second question, Your Honor.
Go ahead.
So, Mr. Lindahl, would you tell the board what your definition of an acquisition agent is, and what an acquisition agent does?
Yes, they collect responses from brokers and keep me organized and saying, hey, we need to respond to this one. We need to talk to the buyer with regards to this asset. We need to discuss, it's in essence an assistant to me in helping me stay organized as we make offers on all these properties.
Do they bird dog the properties for you?
No, I have an application that we created for our business that does it all through technology. So we're a private equity firm. We operate in 32 states across the country.
So through technology, you sort of search different MLSs looking for properties that fit certain parameters.
Yes, there's 117 million single-family homes in the United States, and we track every single one of those every single day. And so when one gets listed on an MLS, then we make those characteristics to make sure it fits our purchase criteria. And if it does, then we make an offer for our buyer on that asset.
Does the acquisition agent fill out the sales contract or offer to purchase?
No, our computer does. So we have a PDF filler, kind of like a DocuSign system. And so when I'm discussing with the buyer and saying, hey, we'll make an offer at $124,500 on this house, I actually put that into the system.
And then once it's filled out, then do you send it to the acquisition agent to forward to the listing agent?
Yes.
You don't just send it directly?
No, we have it sent to the acquisition assistant to forward the document to the agent on the other side of the transaction.
What's the logic in that? Just to put a local face with it?
Yeah, to have a local face to it and to be able to be responsive back and forth on the contracts because the market is so quick today.
So the counteroffer would come back to the local face, who would then plug it into the program, or when does the human decision come in as to how much to say counteroffer?
That's the buyer's decision on how much they would like, and each day we have 2 meetings in the morning and 2 meetings in the afternoon that we go through each one of the offers that we put out.
Okay, thank you.
Who contacts the buyer once a counteroffer comes in?
I do myself and my partner, Rustin, who's the broker in charge of the Nashville office with regards to the state of Tennessee. He's the one that deals with the buyer on the Nashville offers.
What was his name?
Rustin Randall.
Can you spell that for the court reporter, please?
Rustin and then Randall.
Thank you. Go ahead, members of the board.
Did you take the broker management course required in the state of Tennessee?
Yes.
Okay, and obviously you passed it because you have a broker's license. Is there a reason, on all these different pieces of paper, there's like different addresses? Is it your testimony that your your address with the state of Tennessee is the Arizona address?
Correct.
Thank you.
Other questions? Thank you, Your Honor.
I've got one.
Mr. Chick, go ahead.
Mr. Excuse me, Mr. Lindahl, on the Exhibit 3, you notice the exhibit, it says, attached you will find a copy of the investor's cash offer. Correct?
Exhibit 3, is that the Lisa email?
Yes. You see that?
Yeah, I mean, if it's on that
Okay.
email, yes. Uh-huh.
And then there is, in fact, an attachment, right?
There's an attachment that you included on that one, yes.
Okay. Well, I didn't include it. I mean, it was attached by Elisa
There actually,
Werkheiser, right?
it's multiple attachments. There's several documents attached to that email.
Right.
Yes.
But on Exhibit 4, there's no, Ms. Timpano doesn't say there's anything attached, does she?
There's an offer attached, which I could provide to you guys if she doesn't reference it in her email there. But
You and I spoke about this before, correct? On the telephone? Didn't you tell me that there was no written offer with the second email?
no, I did not tell you that. Just like on exhibit number 6, I had an attachment of what can and can't do a non-resident applicant, and it did not end up in this exhibit either.
Again, Mr. Lindahl, we can argue for hours apparently on what you did and didn't attach. You did not file an exhibit list with my office prior to this hearing, as you were required to do if you wanted to submit exhibits. Mr. Chick filed both an exhibit list and an amended exhibit list properly, and we have the exhibits he's produced. You've chosen not to come to Tennessee for this hearing, and we have allowed you to participate by phone, but you didn't give us any exhibits, and we don't have your exhibits, and I'd appreciate moving on with actual testimony as opposed to bickering about something that you failed to do prior to the hearing. Mr. Chick, what was your question for Mr. Lindahl?
My question was, wasn't it true that there was no attachment to the second email, that rather that email was the counteroffer itself,
That's exhibit number 4.
correct?
No, that is not true.
Your Honor, our paralegal's gone to get our recorder where the respondent discussed this. Could we have just a minute to?
Yes, any other questions by the board for Mr. Lindahl?
I'll ask a follow-up question to what Mr. Chick is asking. You're saying there is a counteroffer. What's the date on that counteroffer that you say you have?
You know, I'm on my cell phone right now, and I'm not in front of all my document management system, which is our CRM platform that collects all of our documents.
Mr. Lindahl, did you ever talk directly with Mr. Harper on the phone? Or
Yes.
is this all electronic?
No, I spoke with him on the phone because this offer got somewhat hostile, and I had to step in on the phone and try to avoid.
So at what
Contention.
point did it become hostile?
His first response back to us from our original offer.
Okay, and that was, the original offer was sent to him by who?
By myself, by my assistant, Elisa.
So the offer was sent by your assistant, not by you?
By my assistant from my email.
And you didn't get involved until there was a problem?
I got involved when he immediately responded to that email that the offer was declined, and I picked up the phone and had a discussion with him.
Did he tell you that he was going to contact the Real Estate Commission?
No.
Okay, thank you. All right.
Any other questions by the board? Go ahead.
Mr. Lindell, did I understand you to say that you are a broker in and do business in 32 states?
Our business does, yes. I believe I'm a broker currently in about 24 states.
And you act from your Arizona location and use 18 property acquisition assistants, correct?
Yes.
Okay, thank you.
I have a question.
Ms. Taylor?
Yes, since you act from Arizona, who shows the property?
Our buyer does not look at the properties. They're buying them for an income, not for for any other reason besides the rental property.
So they are never shown to the buyers?
No, the buyer is a large private equity firm, and so it's an entity. So they're actually not going out and seeing these properties.
Thank you.
Just one more quick question about those 18 acquisition agents. Where are those people? Are they in?
They're in my office in Arizona, that 575 address.
So who's in your office in Memphis? Your property management people?
Yes, we have, and those are licensed with the state. And you could see if you looked under our Memphis office that there's some individuals that are licensed with the state of Tennessee that operate our property management business there and do the leasing.
Thank you.
Sir, what name is on the firm, on your firm license?
Main Street Renewal, LLC.
Okay, thank you.
Other questions?
Mr. Chick, I believe you were going to ask him a question about a tape recording.
Your Honor, I'll just leave it as is. That's all the questions the state has.
All right, Mr. Lindahl, any other testimony you would like to provide?
Not at this time. Thank you, Judge.
All right, and are there, you didn't present an exhibit list, so I assume there are no other witnesses you would like to produce?
No.
All right, and Mr. Chick, any rebuttal proof from the state?
Your Honor.
All right, at this time we'll hear closing statements. Mr. Chick, would you like to make a closing on behalf of the state?
Yes, Your Honor.
Go ahead.
Ladies and gentlemen of the commission, you've heard and you've got the exhibits that the state has introduced. As far as the unlicensed activity, you've seen the two emails. The first one clearly referencing an attachment which was attached. Then the second one, which was Exhibit 4, with no attachment, not referencing attachment. The state, reminds the commission that there's been no proof whatsoever that there was a second offer. The state submits that second email was the counteroffer. And the testimony's been that Ms. Timpano is not licensed. There's been testimony that Ms. Timpano is one of 18 property acquisition agents that work in Arizona. It's been evidence introduced that Mr. Lindahl is the principal broker of the Arizona address firm. And Mr. Lindahl is also the principal broker of Main Street Renewals located at 5050 Poplar. And I believe Judge Collier has done a good job of explaining the 62-13-114. That wasn't included by the state because the state didn't believe it was relevant, and I don't think it has anything to do with this case. The fact of the matter is the relevant statute is 62-13-313B, which states that all notices and answers required or authorized to be made or filed under this section may be served or filed personally to the last known business address of the addressee. And there's been testimony from the director, and you've seen the printouts, the RBS printouts that show the business address for Mr. Lindahl is the 5050 Poplar address. That's where the complaint was sent. There is a green card attached to the end of that exhibit where you can see that it was delivered. Now, if Mr. Lindahl wants things to be personally handed to him, then he could do that. But there's been no evidence whatsoever that there was anything unusual about having someone in the mailroom sitting for things. So it was delivered as required. So in summary, I think the state's shown that he's used unlicensed assistance, Miss Timpano, and that he's failed to respond to the complaint. So with that, I'll leave it up to the commission. Of course, the commission can assess civil penalties up to $1,000 for each violation. The commission can also downgrade a license to an affiliate broker. The state would like to stress that the state asks that you for sure assess the cost of hearing an investigation against the respondent. So that's the state's closing, Your Honor.
Thank you, Mr. Chick. Mr. Lindahl, would you like to make a closing argument?
Yes, please.
Go ahead.
I appreciate the opportunity to have my voice heard today, and hopefully I haven't stuck my foot in my mouth too much. But I appreciate the opportunity, and as we're talking about what I've relied on as a broker in the state of Tennessee, I've relied on the information that I've been able to receive from the website. As I'm not an attorney, the statutes and codes are more difficult, but I do affirm and still affirm that my unlicensed assistants have not discussed or explained listings, offers, contracts, or any similar matters with persons as per the Tennessee website, and that all they've acted upon, in my understanding, is that they've delivered documents and worked within the license rules that I am aware of as a licensee in the state of Tennessee. Also, with regards to service, I've tried to make it clear that my business address is not the Poplar address. My business address is the 575 West Chandler Boulevard address, which the state is aware of. That I do not reside in the state, that I filed the form with the state of Tennessee required to become a licensee of the consent to service of outside of the state, as I'm not a resident of the state. And hopefully, as someone who's operated and acquired many properties and managed many homes in the state of Tennessee without any complaints, that we're able to look at my track record, my history, my ability to perform in the state, to bring revenue and high quality housing to the state of Tennessee, to a substantial amount of the state, and that the state will look at my record and history and my ability to work within the laws of the state of Tennessee as a good representation of who we are as a business and who I am as a businessman and a principal broker in the state of Tennessee, and appreciate the opportunity, and thank you.
Thank you, Mr. Lindahl. Mr. Chick, do you have any rebuttal?
Just briefly, Your Honor, I would like to point out to the commission that he mentioned that he's not a resident. Well, the firm in Memphis, Tennessee is a resident. So I think it's kind of interesting that he expects to do business in this state, but he doesn't want to have to receive mail in the state. And I think that's a little repugnant to the whole licensing scheme, but that's all the state has.
Thank you, Mr. Chick. Members of the board, you have now heard the proof and the case before you. It is now my duty to charge you as to the law you must follow in reaching your decision. You are the exclusive judges of the facts in this case. You also are the exclusive judges of the law, specifically your statutes, rules, and regulations, and their application to this case. You should apply the law to the facts in deciding this case under the directions of my charge. You exclusively have the authority to make findings of fact and reach conclusions of law in this matter. No one else can participate in your deliberations. However, if you find that you need to have the law or legal terminology explained to you, I can assist you. The state has alleged that the respondent has violated certain of the state's applicable statutes and rules. It is the state of Tennessee's burden to prove those allegations by a preponderance of the evidence. Do not confuse this standard with the higher standard of beyond a reasonable doubt used in criminal court proceedings. A preponderance of the evidence means the greater weight of the evidence, or that there is sufficient proven information to cause you to believe that the state's allegations provide the more probable conclusion based upon all of the evidence presented. You must limit your inquiry into violations of rules and statutes to those that were specifically alleged in the state's notice of charges, and you must base your determination solely on the evidence presented to you during this hearing. You must not infer from any of my rulings or instructions that I hold any view or opinion for or against either party. None of my remarks have been intended to indicate an opinion as to the facts or what your decision in this case should be. If in these instructions any direction is repeated or stated in varying ways, it is for clarity, not special emphasis. You are not to single out any single sentence, individual point, or instruction and ignore the others, but are to regard each in the light of the others. The order in which the instructions are given does not signify their relative importance. The evidence consists of the testimony given by the witnesses during the hearing and the exhibits introduced into evidence. I believe we have exhibits numbered 1 through 8 that you all should have copies of. If anyone has misplaced their copy, let me know and I will pass you the original exhibit. Statements and arguments by the attorneys in the case and documents contained in the technical record, such as the notice of charges and any proposed findings of fact or conclusions of law that should be submitted by the state, are not evidence. You may use these arguments and documents to assist you in making your findings of fact and conclusions of law, but you should do so only after careful consideration and a determination that they accurately reflect your own independent recollection of the evidence and your own conclusions from the evidence. You must make your findings of fact based solely on the evidence presented to you during the hearing. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony of a witness about what the witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what has happened. Circumstantial evidence is proof of a fact or a group of facts that cause you to conclude that another fact exists. It is for you to decide whether a fact has been proven by circumstantial evidence. If you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. For example, if a witness testified that the witness saw it raining outside, that would be direct evidence that it was raining. If a witness testified that the witness saw someone enter a room wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence from which you could conclude that it was raining. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any particular piece of evidence. In making your decision, you must consider all of the evidence in light of reason, experience, and common sense. You are the sole and exclusive judges of the credibility or believability of the witnesses who have testified in this case. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules to use in deciding whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see, hear, or be aware of the things about which the witness testified? How well was the witness able to recall and describe those things? How long was the witness watching or listening? Was the witness distracted in any way? Did the witness have a good memory? Was the witness making an honest effort to tell the truth, or did the witness evade questions? Did the witness have an interest in the outcome of the case? Did the witness have any motive, bias, or prejudice that would influence the witness's testimony? How reasonable was the witness's testimony when you consider all of the evidence in this case? Was the witness's testimony contradicted by what the witness has said or done at another time, by the testimony of other witnesses, or by other evidence? In making your findings, the board or commission must make the sole determination as to the credibility and weight to be given to the evidence presented by each witness. If there is a conflict in the testimony between witnesses, it is the responsibility of the board to reconcile those conflicts if possible. But if it is impossible to reconcile the conflict between the witnesses, the commission must make the determination as to which witnesses to give the most credibility. In reaching its determination, the commission should keep in mind the following principles of law. The law presumes that all witnesses who are sworn to oath will testify to the truth. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses. But if this is impossible, it is necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the commission as a fact finder has wide discretion. However, the commission should consider, in determining the truth, the witness's interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, and their conduct and demeanor on the witness stand. The law does not require you to accept as true all of the evidence that I have admitted, even though it is legally competent. In determining what evidence you find persuasive, you must make your own evaluation of the testimony given by each of the witnesses and determine the degree of weight you choose to give that testimony. The testimony of a witness may fail to conform to the facts as they occurred because that witness is being other than truthful, or because that witness did not accurately see or hear that about which he or she testifies, or because his or her memory of an event is faulty, or because he or she has not expressed himself or herself clearly in giving testimony. You have the duty to determine the credibility and weight to be given to the evidence presented by all witnesses. Under the law, it is presumed that all witnesses tell the truth. If there is a conflict in the testimony between witnesses, you must first try to reconcile these conflicts whenever possible. If it is not possible to reconcile conflicting testimony, you must make the determination as to which witness should be given the most credibility. Although you must consider all of the evidence, you are not required to accept all of the evidence as true or accurate. You should not decide an issue by the simple process of counting the number of witnesses who have testified on each side. You must consider all of the evidence in the case. You may decide that the testimony of fewer witnesses on one side is more convincing than the testimony of more witnesses on the other side. There may be discrepancies or differences within a witness's testimony or between the testimony of different witnesses. This does not necessarily mean that a witness should be disbelieved. Sometimes when two people observe an event, they will see or hear it differently. Sometimes a witness may have an innocent lapse of memory. Witnesses may testify honestly, but simply may be wrong about what they thought they saw or remembered. You should consider whether discrepancy relates to an important fact or only to an unimportant detail. The state has charged the respondent with certain violations of your statutes and your rules. For each of these charges, you must determine whether the alleged violation has been proven by a preponderance of the evidence and specify in the findings of fact portion of your order the specific underlying facts that support your decision. In making your determinations, it may be necessary for you to interpret your statutes and your rules. When the language of the statute or rule is plain, then you must follow the plain meaning of that language. However, if the language is ambiguous, you may give your interpretation of that language so as to explain the conclusion you reach as to the violation charged. If in your deliberations you find that one of your statutes or rules is ambiguous and you are uncertain as to how to interpret it, please let me know and I will give you a more detailed charge on statutory construction. Although you may only consider the competent evidence presented during this hearing in making your decisions, this does not mean you are required to set aside your common knowledge or expertise in the field of real estate. You may, and in fact should, weigh the evidence in light of your training and your own observations and experience. You should always keep in mind that the state of Tennessee bears the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. The Administrative Procedures Act specifically requires your order to contain 4 sections: findings of fact, conclusions of law, a decision regarding what disciplinary action shall be taken, if any, and the policy reasons for your decision and determination. In making findings of fact, you must make your own evaluation of the testimony given by the witnesses and any documentary evidence admitted during the hearing. You must then give that testimony or other evidence the weight and credibility that you deem proper. You may weigh the evidence in light of your own training and expertise. Once you have made findings of fact, you must decide if the respondent's activity constitutes a violation of departmental or board rules or state statutes as alleged in the notice of charges, and if so, you must state those determinations in your conclusions of law. Your decision must include sufficient analysis of the evidence to clearly demonstrate how the facts of the case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate linkages and connections between the 2 sections of your final order. If you decide that there has been a violation of a state statute or rule, you must then decide what disciplinary action is appropriate in accordance with your legal authority and considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of the appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. Additionally, you may also consider what you have done in previous similar cases. Under the law, administrative agencies are not required to have absolute consistency in the disciplinary action that they take. However, this does not mean that you may be arbitrary and capricious in dealing out disciplinary actions. Disciplinary actions must be based on fairness and reason. Finally, a policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your deliberations must be in public before all parties. If you need assistance with the law or the structure of your order, I will be available to assist you. Any action taken by the board must pass by a majority vote of the panel. If you have any questions about the facts presented, you may, by a majority vote, reopen the proof and hear further testimony from witnesses and/or oral argument from counsel. Does either party have a proposed order, including proposed findings of fact and conclusions of law?
State does not.
The state does not. Mr. Lindahl, did you prepare a proposed order?
I did not.
Okay. At this time, unless there are questions from the board concerning my charge, I will now turn the hearing over to the board chair to preside over your deliberations, after which you will make findings of fact, reach conclusions of law, including a decision regarding whether any disciplinary action shall be taken, and if so, determine what disciplinary action shall be taken, and give your policy reason for your decision. Mr. Chairman?
Thank you, Your Honor. Let me poll the board here and see if you would like to take a break before we start deliberations. We're okay to go? Well, I've got a request. Let's take about if Your Honor, if you want to instruct us, if we take a 7-minute break before we
can take a 7-minute break before we go to, do not discuss the case or any of the facts about it among yourselves or with anyone during the break, and we will convene in approximately 7 minutes.
Perfect.
All right, Mr. Chairman, we're all back.
All here.
Mr. Lindahl, are you still with us?
I am here.
Excellent. All right, Mr. Chairman, we're all back from the break, and I will now turn it over to you all to conduct your deliberations, after which you will prepare a final order that should include findings of fact, conclusions of law, a disciplinary action, if any, that you choose to impose, and if so, what that disciplinary action is, And finally, a policy reason for your decision.
Thank you, Your Honor. Commissioners, or any opening statements or comments or questions you'd like to just put out before we get started with finding the facts? All right, if there are none, are there findings of facts that any particular commissioner would like to offer in the form of motion?
Commissioner Grease, I move that respondent was at all times pertinent hereto licensed with the commission as a real estate broker, license number 331452. Second.
The motion by Commissioner DeCharo is a proposed finding of fact. And so if you agree that fact has been proven, you'll vote yes. If you don't believe it has been proven, you'll vote no. All right, let's vote on the proposed finding of fact offered by Mr. Chara. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, vote no. Mr. Chara,
I move that respondent was at all times pertinent hereto principal broker of Main Street Renewal LLC, a licensed real estate firm. Second.
motion by Commissioner DeChara, second by Commissioner Franks. Does that finding of fact get adopted by this commission? If you're in agreement, please vote aye.
Aye.
If you're opposed, no. The motion passes unanimously.
I move that respondent employed or compensated an unlicensed person, Kim Timpano, to solicit, negotiate, or attempt to solicit or negotiate the purchase of real estate known as 2503 Branch Place, Murfreesboro, Tennessee, 37130, on or about May 20th, 2015. Second.
Okay, the motion is to adopt a finding of fact that basically, as I understand the motion, if ratified by this commission, would say that this what exhibit is that on?
Exhibit 4.
That Kim Timpano was employed and compensated by the principal broker, Mr. Lindahl, and was used to negotiate the purchase of a piece of property in Tennessee. Is there discussion on that motion? I didn't state it. Greg, would you like to repeat it again? I don't like how I stated it.
Respondent employed or compensated an unlicensed person, Kim Timpano, to solicit, negotiate, or attempt to solicit or negotiate the purchase of real estate known as 2503 Branch Place, Murfreesboro, Tennessee, 37130, on or about May 20th, 2015.
May I ask a question?
Absolutely. We can
Did
discuss
you
these at length.
Yeah,
if
if you said in the first that she was employed and or compensated, is that what you said? Okay, I just wanted to make sure I heard it correctly.
I did second it.
Is there other discussion on that? So, just from my perspective, I don't know that I saw evidence that caused me to believe that she was employed or compensated to do this. May have happened, and it may have been an oversight on management's part, but from an evidence point of view, I don't think anybody showed me a pay stub, or I have any reason to think that she was compensated for doing this particular item.
Well,
she may work for
witness
free.
said she was an employee.
Y'all do one at a time, please.
He said she was a property acquisition assistant for him, and most people don't do that for free.
Well, I'm not arguing the point too much, but I'm just saying from a compensation point of view, I didn't hear any evidence.
And neither offered that, so we have to make a decision without it if we don't have it. Although Mr. Lindell did say he employed her as an acquisition agent.
Agree with that. I agree with that.
Mr. Wood, do you have a comment?
I agree. I don't think people do much work without compensation nowadays.
Except me.
All right, so the motion on the floor, you've heard the proposed finding of fact. If you're in agreement with it, please vote aye.
Aye.
If you're opposed, vote no. That finding of fact is adopted.
On or about July 31, 2015, the commission mailed a certified letter to respondent at respondent's address of record notifying respondent that a complaint enclosed herewith has been filed against respondent, and the respondent was required to respond in writing within 10 days of respondent's receipt. Second.
All right, Mr. Charles made a proposed finding of fact, but recommended that we approve a finding of fact related to service of a complaint dated July 31st, 2015. It was properly seconded by Ms. Franks. Is there discussion on the motion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That finding of fact is adopted.
I move that the certified letter receipt was signed on August 5th, 2015, thus constituting respondent's receipt. Second.
Mr. DeChara has offered a proposed finding of fact that delivery was indeed accomplished at the Memphis address. Did you say the Memphis address?
The respondent's address as
Okay,
on
respondent's
record.
address record. Properly seconded by Ms. Franks. Is there discussion on that motion? All right, if you agree with that motion, please vote aye.
Aye.
If you oppose, vote no. That finding of fact is adopted.
I move that respondent provided no response to the complaint until after receiving a consent order on or about October 21st, 2015. Second.
Motion by Commissioner DeChara, second by Commissioner Franks. If you agree, you'll adopt that finding of fact by voting yes. Is there discussion? If not, then let's vote. If you're in favor of the motion, vote yes.
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 I thought I changed up to aye just for the heck of it. Okay. That finding of fact is adopted. You done?
I'm done.
Are there other findings of fact that commissioners would like to offer?
I'm asking the question. We missed Alicia Workhauser. Was she left out of your finding of fact?
I do not, after reviewing the case, it does appear that she just forwarded documents.
Right.
Because when I asked him, he said that his name was, she did ask that he contact Mr. Lindo.
And
Yes.
it is on the email.
Right,
I just was making
right.
sure that. Okay.
Well, even that could be a finding of fact if you'd like to state it. But if you don't think it's relevant, that's also okay.
It's not pertinent, I don't think.
I think we're good. I just wanted to make sure.
Could,
Ms. Hills?
could the fact that
Are you looking for, Diane? Compensation agreement on number.
Exhibit 3, well, next to the last page on Exhibit 3, compensation agreement,
What's your question about it, Diane?
about finding a fact that Mr. Lindell has firm address is Arizona.
A finding of fact is strictly something you believe has been proven. So if you'd like to offer that finding of fact.
I think I'll wait. Oh, well, thank you.
Hey, commissioners.
Give me a moment.
Take your time.
It does seem that if he put the Arizona address on his compensation address, although he's licensed in the state of Tennessee, that is an issue.
It's what's on file at TREC, not what he puts on contracts.
I got you. All right. Well, let's just thank you. Thank you. So I'm good.
Just, we have some new commissioners, new audience members, and generally, the litigant's attorney will provide us an outline of some proposed findings of facts, which we did not receive. And so, for those of you who think we might be struggling up here at the moment, we are. We have an outline to work with. So, I'll just make that point, Mr. Chair.
Mr. Grease, I would like to remind the commission that the last hearing, I was instructed that the commission does its own findings of fact. So that's why I didn't.
I don't recall any instruction like it's a different topic we talk about after. We always appreciate.
Let's move along with the deliberations, members of the commission. Mr. Chick, if they want to hear more from you, I'm sure they will reopen the record and ask for
We're
that.
good.
All right.
I think from your discussion, did you all want a finding of fact with regard to what the address is?
We're still.
I'm okay. I'm okay too. I just wanted to make sure.
All right, commissioners. Any other findings of fact that you'd like to offer? If not, then we move to the second portion of our deliberations, which is to identify possible conclusions of law applicable to this case. Does any commissioner have? Let's go, Mr. Chart. Tell us what you think.
I move that the acts alleged in paragraph 11 constitutes action of a broker, and that's the, well, actually, it's findings of fact number 3, constitutes actions of a broker pursuant to Tennessee Code Annotated 6213-102-4A, which provides in part, broker means any person who, for a fee, commission, finder's fee, or any other valuable consideration, or with the intent or expectation of receiving a fee, commission, finder's fee, or any other valuable consideration from another, solicits, negotiates, or attempt to solicit or negotiate the listing, sale, purchase, exchange, lease, or option to buy, sell, rent, or exchange for any real estate. Second.
Okay, you've heard the motion. Frankly, it was read fairly close to verbatim on page 3 of the notice of hearing charges. In case you'd like to just take a look at it. Have a proper motion and a proper second that this is a conclusion of law applicable to this case. Is there discussion on the motion? If you agree, please vote aye.
Aye.
If you're opposed, vote no. Thank you. Mr. Chara.
I move that acting as a broker in regulation by Title II, Chapter 13 of Tennessee Code Annotated, specifically TCA 6213-301, provides in part, it is unlawful for any person directly or indirectly to engage in or conduct, to advertise or claim to be engaging in or conducting the business or acting in the capacity of a real estate broker as defined in 6213-102 within the state without first obtaining a license as a broker, affiliate broker, timeshare salesperson, or acquisition agent as provided in this chapter. Second.
All right, you've heard Mr. Chara read the record. Her second proposed conclusion of law is properly seconded by Commissioner Franks. Is there a discussion on that motion? All right, then let's vote. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. Mr. Chara.
I move that respondent, by employing or compensating Kim Timpano for performance of the acts set forth in findings of fact number 3, violated Tennessee Code Annotated 6213-302A, which provides in part, it is unlawful for any licensed broker to employ or compensate any person who is not a licensed broker or a licensed affiliate broker for performing any of the acts regulated by this chapter. Second.
Motion by Commissioner Chara, second by Commissioner Franks, that conclusion of law is applicable to this case. Is there discussion on the motion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously.
I move that respondent's violation of TCA 6213-302A constitutes grounds for the commission to suspend, revoke, or downgrade respondent's broker's license pursuant to TCA 6213-312, which provides in part that the commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform.
Mr. Lindahl? Mr. Lindahl, are you still there?
I'm here.
Okay, we're getting some severe static, and I was trying to figure out if that was at your end or our end. It seems to have gone away. All right, go ahead, Mr. Chara.
Perform any of the acts mentioned herein is found guilty of number 14, violating any provisions of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the commission. C, the commission may, in addition to or in lieu of any other lawful disciplinary action against a broker pursuant to this section, order that the broker be downgraded to affiliate broker status. Second.
You've heard Ms. Tachara read into the record her proposed conclusion of law. It's been properly seconded by Ms. Franks. Is there discussion on that motion? Yes, Mr. Horn.
I don't know if I got complete what you were saying. It's to downgrade the status of the election holder. Is that right?
We do have the authority to downgrade his license.
So what are we saying now?
We're
Not decided that
We're
yet.
just saying that we do have that authority.
This is just conclusions of law that we're.
Yeah. Okay.
the next step will be discipline, if there is any. All right, you've heard the motion. Thank you for the question, Mr. Horn. Is there discussion on the motion? Let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Mr. Char.
I move that respondent's violation of TCA 6213-302A also constitutes grounds for the commission, in addition to other lawful discipline, to assess a civil penalty of up to $1,000 against respondent pursuant to TCA 56-1-308A, which provides, with respect to any person required to be licensed, permitted, or authorized by any board, commission, or agency attached to the Division of Regulatory Boards, each respective board, commission, or agency may assess a civil penalty against the person in an amount not to exceed $1,000 for each separate violation of a statute, rule, or order pertaining to the board, commission, or agency. Each day of continued violation constitutes a separate violation. Second.
All right, you've heard the conclusion of law recommended to be adopted by this commission. It's been properly made by Commissioner Tachara, seconded by Commissioner Franks. Discussion on that motion. All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that respondent's violation of TCA 6213-302A also constitutes grounds for the commission to assess cost of hearing and investigation against the respondent pursuant to TCA 56-1-311A, which provides, notwithstanding any contrary law, the Division of Regulatory Boards or any board, commission, or agency attached to the division of the Regulatory Board may assess the actual and reasonable cost of the investigation, prosecution, and hearing of any disciplinary action held in accordance with the contested case provisions of the Uniform Administrative Procedures Act, compiled in Title IV, Chapter 5, Part 3, and in which sanctions of any kind are imposed on any person or entity required to be licensed, permitted, registered, or otherwise authorized by the division or respective board, commission, or agency. These costs may include, but are not limited to, those incurred and assessed for the time of the prosecuting attorneys, investigators, expert witnesses, administrative judges, and any other persons involved in the investigation, prosecution, and hearing of this action. Second.
Motion to adopt that conclusion of law properly seconded by Ms. Franks. Is there discussion on the motion? All those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that respondents' failure to respond in writing with 10 days of receiving notice of the complaint constitutes violation of TCA 6213-313A2, which provides the accused applicant or licensee shall, within 10 days, file with the commission the applicant's or licensee's answer to the complaint, a copy of which shall be transmitted to the complainant. Second.
All right, Mr. Char has offered that proposed conclusion of law has been properly seconded by Ms. Franks. Is there discussion on the motion? All those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
I move that respondents' violation of TCA 6213-313A2 constitutes grounds for the commission to suspend, revoke, or downgrade respondents' broker's license pursuant to TCA 6213-312, which provides in part, B, the commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 14, violating any provision of this chapter, any rule duly promulgated and adopted under this chapter, or the terms of any lawful order entered by the commission. C, the commission may, in addition to or in lieu of any other lawful disciplinary action against a broker pursuant to this section, order that the broker be downgraded to affiliate broker status. Second.
Mr. Char has offered that conclusion of law that's been properly seconded by Ms. Franks. Is there discussion on her motion? All in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
I move that respondents' violation of TCA 6213-313A2 constitutes grounds for the commission, in addition to order lawful discipline, to assess a civil penalty of up to $1,000 against respondent pursuant to TCA 56-1-308A, which provides, with respect to any persons required to be licensed, permitted, or authorized by any board, commission, or agency attached to the Division of Regulatory Boards, each respective board, commission, or agency may assess a civil penalty against the person in an amount not to exceed $1,000 for each separate violation of a statute, rule, or order pertaining to the board, commission, or agency. Each day of continued violation constitutes a separate violation. Second.
You've heard the proposed conclusion of law offered by Mr. Chara. It's been properly seconded by Ms. Franks. Is there discussion on that motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That conclusion of law is adopted unanimously.
I move that respondents' violation of TCA 6213-302A constitutes grounds for the commission to assess cost of hearing an investigation against the respondent pursuant to TCA 56-1-311A, which provides, notwithstanding any contrary law, the Division of Regulatory Boards or any board, commission, or agency attached to the Division of Regulatory Boards may assess the actual and reasonable cost of the investigation, prosecution, and hearing of any disciplinary action held in accordance with the contested case provisions of the Uniform Administrative Procedures Act, compiled in Title IV, Chapter 5, Part 3, and in which sanctions of any kind are imposed on any person or entity required to be licensed, permitted, registered, or otherwise authorized by the division of respective board, commission, or agency. These costs may not limit but are limited, or may include but are not limited to, those incurred and assessed for the time of prosecuting attorney, investigators, expert witnesses, administrative judges, and any other persons involved in the investigation, prosecution, and hearing of the action. Second.
So Mr. Chara has offered that conclusion of law, hopes to get a positive vote on it. It's been properly seconded by Ms. Franks. Is there discussion on the motion? All right, then let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Anything else, Ms. Bachara?
That concludes our conclusions of law.
That's your conclusion.
That's my conclusion.
Yeah. Do other commissioners have conclusions of law? Mr. Wood?
I'm not trying to break. Janet's doing a great job of doing the heavy lifting here. But I have a question: can we go back and can we add a finding of fact, or once we've kind of stopped doing that, we're done?
You have not finished your order, so if you would like to make a motion to add a finding of fact, you're welcome to do so.
Okay, I'm gonna make this motion, and y'all want to second this one?
Let's do this real quick. Are there any other conclusions of law the commissioners want to offer? All right, I just want to make sure.
And help me if we've already addressed this,
We
but
need to vote on that one.
Did we not vote? I thought we did. Did we vote?
I thought you did, but you can do it a second time.
Nice.
In the event we fail to vote on that last motion offered by Commissioner Char or properly seconded by Commissioner Franks, let's vote again. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no. Commissioner Wood.
on the Tennessee Real Estate Commission website, where it refers to what can't an unlicensed employee, assistant, or secretary do, which is the same as Exhibit 8 today. And the fifth item mentioned there was said a finding of fact is that unlicensed person is not allowed to negotiate any terms of a real estate transaction.
Second.
All right, so we're back to findings of fact for a second. Mr. Wood has asked to add, made a motion that was properly seconded by Commissioner Chara that the finding of fact be added to our list of previously generated findings of fact. Mr. Wood, would you repeat it once more since I'm over here coughing?
That from the Tennessee Real Estate Commission website refers to what can an unlicensed employee, assistant, or secretary do. And the fifth item mentioned, it says negotiate any terms of a real estate transaction.
All right, that's the proposed finding of fact offered by Mr. Wood. It's been seconded by Mr. Chara.
I got a bit of discussion. It seemed that we read from the booklet, trying to determine exactly what the wording was saying on the website. And I did not come to a conclusion whether they agreed or disagreed. But the idea is, I suppose, that the rules should be taken from the booklet. Is that right? And I'm saying that we need to be careful that we say on the website exactly what the law is and not leave room for interpolation.
And it came from Exhibit 8 right there in front of us. That was a copy of the website information. So I read off the website.
Would you amend to include the discuss or explain above, to include that in your motion?
Yes, I would.
Okay, the finding of fact now in front of commission includes two parts, both taken from the website, Tennessee Real Estate Commission, titled "What Can't an Unlicensed Employee or Assistant or Secretary Do?" The motion, as I understand it, references the fourth item on that list, which is discuss or explain listings, offers, contracts, or other similar matters with persons outside the firm, and the fifth item on that website page, negotiate any terms of real estate transaction. That's your motion, Mr. Wood.
That's my motion.
It was seconded by Mr. Chara.
Yes, I did.
That's the motion that's in front of us at this point. Is there discussion on the motion? All right, let's vote on that motion. It's a finding of fact. It's proposed finding of fact. If you agree. If you don't think it's a finding of fact, vote no. All right, that motion passes. Thank you, Mr. Wood. Anything else? Mr. Wood?
No, I'm good.
Any other finding or conclusions of law?
Do we need the conclusion of law to go with that? The numbers that would violate?
The judge asked us to tie findings of fact in with conclusions of law.
Right, so that's my question, Mr.
Mr. Chairman, can you move your mic down, please?
I apologize. Thank you. I was coughing. I forgot.
So
That's a finding of fact, not a conclusion of law.
okay.
Is that correct?
Yes.
Mine was a finding of fact.
Yes.
So it's it's my sense that the conclusions of law that were written, record and adopted would cover that as well.
It would under 6213-312.
All right. So let's assume we're through the first two phases of what we're required to do, which is find facts and come up with conclusions of law. The third step is to talk about discipline and establish what this commission would like to do in the form of discipline. Are there any commissioners? Is there a commissioner who would like to start this conversation?
I'd like to make a motion.
All right, that's a good start. Ms. Franks, go ahead.
Okay, I would like to make a motion that we find that Spencer Lindahl did indeed hire an unlicensed person, Kim Timpano, to do his real estate work, and that he also, on count 2, was found guilty of not responding appropriately.
All right. Well, let's say that we've already.
We're okay with that. Okay.
We've got those findings and facts.
Okay.
What do you want to do?
All right. So what I would like to do is I would like to assess him $1,000 on each of the 2 cases, and also fine him the cost of the investigation and the hearing, and downgrade his license to affiliate broker.
Is there a second to that motion?
Second.
All right. Is there discussion on the motion? Mr. Horn.
Yes, sir. I do not know the organization of Mr. Lando, but it seems to me that a lot of people are affected here, and that they are breaking in a lot of businesses, doing a lot of things. But however, some things has been neglected, and that's what we're talking about now. But on the other hand, I would agree everything said except downgrading the license, because I think that we've got their attention, and I don't see that the whole organization be reshuffled because of the way they do business. And like I say, I hope we never see it again, but the idea again, I think we ought to reconsider downgrading the license.
Mr. Horn, my reasoning for that is he does have a large organization. There's bound to be other people that can step in today to be his principal broker. He has also 18 of these agents, the people who are not agents, unlicensed people. So I don't know what he has. I just know he's only been a broker. He was only a broker for 4 months when this happened. And I think in an operation as big as his, there's somebody else that could step in as principal broker. Was my reasoning.
Ms. Hills.
I feel that evidently with his broker's license, a lot of times we forget, but he had just taken his Tennessee part of law as to what the requirements are for an office, for a broker, for a non-resident broker. I'm not a fan personally of non-resident brokers, but that's not the law. I can't let that interfere. But I too am very concerned that he would hold the broker's license, and with the evidence that we've seen.
Other comments, Mr. Wood.
I'm going to ask a question. You said it was $1,000 fine for the 2 things, or 2 violations. Is the violation 1 the unlicensed activity, and the other one not responding?
Right.
Okay.
Right.
And I'm going to agree with Mr. Horn. I'm not so sure right yet. I'm so sure that I necessarily want to downgrade the license. So, but I agree with the other part of this.
All right, so the chair is going to take the chair's prerogative, unless he's overruled by a majority of this commission, and separate the question as it relates to these discipline suggestions offered by Commissioner Frank. And so once discussion is over, I propose that we vote on each of those three disciplines proposed by Commissioner Franks individually. Okay, so we can get a sense and everybody can vote as they see fit. Is there objection to that?
That's fine.
That's great.
All right, is there further discussion about this before we do vote? All right, I sense we're ready to vote. Let's take the first proposal offered by Commissioner Franks, properly seconded by Commissioner Chara, which was to offer a civil penalty of $1,000 for each violation or sum of $2,000. That's the motion that's on the floor. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That portion of Ms. Frank's motion passes unanimously. The second is to cause all the costs associated with this hearing, as specified by Ms. Franks, to be charged to the respondent.
And the investigation.
That's whatever you listed, I'm with you on that. Okay. It includes specifically the court reporter too. Hadn't been mentioned specifically yet, but we want to make sure we know you're getting. All right. So the motion is, as you heard it, to assess cost to the respondent. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. That portion of Ms. Frank's motion passes. The third portion of Ms. Frank's motion was to downgrade Mr. Lindahl's license from broker to an affiliate broker status. Is there discussion on that motion before we vote, or have we heard all the discussion we need?
I have a discussion. It concerns me, and I certainly know it's legal, but that he's a broker in 24 states. I don't see how anybody can be a broker in 24 states and really keep abreast of what the laws are in each particular state. And I don't see how they can, that's almost an impossibility to me for anybody to do that and do it well by the laws of the state. That's what I mean, well.
Thank you. Other comments or discussion? Did you want anything else, Ms. Taylor? What's that?
Well, it's clear that they don't show the property. It's very clear that they just are somewhere else. Just he has his license as a convenience, not as a real, to me in my eyes, working broker.
Comments?
And maybe Fontaine kind of led right into what maybe I was thinking, because there's so many different states and stuff involved. Maybe some continuing education be helpful here, and maybe education in agency and contracts. And so I would more propose maybe 4 hours of education for an agency and minimum 4 hours in contracts. That might be a more appropriate solution maybe than downgrading license.
So we'll consider that. Right now, what's in front of us is the third portion of Ms. Franks' motion that would downgrade the license to affiliate broker if it passes. Ms. Hills.
The documentation, on the compensation agreement, for example, the address of the firm, which I would naturally think, since you're operating in Tennessee, would have been a Tennessee address, since he has at least two that he testified, at least two locations in Tennessee. He did not use a Tennessee address. I don't know where there are rules for how your office is, and I don't know that those have been met. But he put on his own form his address is in another state, even though I know he's a non-resident broker. I just think there's confusion there for then the public and him as a broker.
Sills.
Well, maybe that's where Mr. Wood's comment about some education might be beneficial.
Other comments? Okay, the motion that's in front of us, Mr. Horn.
I agree that he's probably busy,
What?
busy
Busy.
because he has so many irons in the fire. But however, I'm thinking that that education is probably what's needed here more than a downgrade for the simple reason that it probably hurt worse than a downgrade. Because, like you said, there were so many people who could walk in and take that position. But I know my time is valuable, your time is valuable. So, what I am saying, and I think that it might be a good thing to look to the future, that when people do things that could be questionable, well, I got it off the website, I did this, or this person is not authorized to tell me to that these what my charges are, this type of thing. I think that they're treading water. So I believe that I would push toward education.
Ms. Hills.
I can see that, but my concern is that I would guess that it would be done online. There's no way to know who's taking that class online. And I don't think we could specify that he attend a class. I think the fact that he didn't attend an important hearing, I don't see why he would attend a class. So I don't know who may be taking the online class. And that's my concern with education, even though I do agree, I think there needs to be education. If that's it, I'm concerned about that.
He's required 120 hours after he gets his broker's license. Now, we don't know if he's completed that or not. He may have. But that's a very important part of getting a broker's license, and especially if you're going to be the principal broker, that those 120 hours be taken.
Other comments, Ms. Taylor.
He's already said he has a broker in Nashville, so I mean, downgrading his license to me is not much of a slap on the wrist because he'll just get the broker from Nashville to step in.
Well,
I don't know. I just think we need something to get his attention. That's what I'm trying to say, whatever that might be.
Other comments? All right, the motion on the floor, which we're about to vote on, and we'll probably do it by roll call vote, it's the sense of this chair, is to take Mr. Lindahl's broker's license and downgrade it to an affiliate broker's license. When your name is called, if you're in favor of that, you'll vote aye. If you're opposed to it, you'll vote no. All right, Mr. Young, would you mind doing us the honor?
Wood.
Make sure your mic's going. Thank you.
Mr. Wood?
No.
Ms. Franks?
Yes.
Ms. DeChera?
Yes.
Mr. Reese?
No.
Ms. Hills?
Yes.
Ms. Taylor?
Yes.
Mr. Horn?
No.
According to the vote tally, the motion passes on a 4 aye, 3 no vote. All right, Mr. Wood, you had a proposal or a suggestion?
I think I'm fine now.
All right. So just to summarize, Ms. Frank's motion contained 3 parts. All 3 parts were approved by commission. And at this point, unless someone else has a motion related to discipline, we'll move on to the 4th part. All right, the statute of something requires us to come up with a policy statement.
Can you tell me, Judge, again what all needs to be in that policy statement, please?
I can. A policy reason must accompany your determination to state why the decision you render in this situation is appropriate. Your policy reason is your statement explaining why the particular disciplinary action you choose in this case is correct, given the wide range of cases you hear and the various disciplinary options you have. Your policy reason tells the public and reviewing courts why the disciplinary action you choose in this case is proper, even though it may be a little different from what you have done in past cases or what you may do in future cases. The gravity of the violation and the respondent's attitude toward the action may be included in your policy statement to support your disciplinary action. This does not have to be a long statement. However, it should not be just a reiteration of the facts you have found in the case or adoption of your statutory authority to hear the case. Rather, it is simply a short statement as to why the disciplinary action you have chosen today is correct.
All right, we believe that the respondent has violated TCA 62.13.302 by allowing a non-licensees to negotiate contracts, and also violated 62.13.313 by not responding to the complaint when it was filed. These are serious violations when you are a managing broker, that you are allowing non-licensed agent or non-licensed people to participate in negotiating contracts. Also, when the commission files a complaint against you, a response is required. It's not something you can just look at and go, oh, well, I'll get around to it. It is required within 10 days, and we feel very strongly about that. For that reason, we have made our decision.
You'd have to have a second.
Second, please.
Okay. Is there discussion on the policy statement proposed by Mr. Chara? Since there is not, let's vote on their motion. If you're in favor, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. All right, Your Honor, I think we've done our part.
Thank you, Mr. Chairman.
Pass it back to you.
Yeah, thank you, Mr. Chairman and members of the board. Mr. Chick, if you would draw up the order for signature by the board chair. Once it is signed by the board chair and filed in my office, it also needs to have a signature line for our director, Richard Collier, so that it will show the date it was filed at APD. Once it is filed in our office, it is an effective order. Mr. Chick, if you would also include appeal rights with that order, that way Mr. Lindahl will know what appeal rights he has if he would like to appeal the final order of the board to Chancery Court. At this time, unless there are any motions, I will adjourn the hearing. All right, the hearing is adjourned. Mr. Chairman, do you all have other business or?
Just a couple minutes.
All right, well, I will turn it back to you for any other business and we will stand adjourned.
Thank you very much. Now, Mr. Chick, so who told you never to bring us?
I believe that was you.
No, I believe we had an attorney up here that wasn't here today, and he added to your proposed findings of fact. And I think you might have been amazed that we could actually add to the list, but we certainly always would like to have your input.
Okay, I might have misunderstood you, Mr. Chairman, but
That's a good answer.
that's the only reason I didn't prepare, but I didn't, you know. But next time I'll do it just in case.
Yeah, I would, because we can't always count on Mr. McMullen to be here with us.
Okay.
Although we're thrilled when he is, I
All
promise
right.
you.
Thank you all very much.
All right, commissioners, anything, Janet, you want to say while you still have a little voice left?
I think I'm good. Have a good Easter, everybody, and safe trip home.
Ms. Hills, Diane,
Just be careful. Thank you.
Ms. Taylor, Mr. Horn.
Yeah, just happy Easter to everyone and good
Kind of
working
to
with
sign
you.
out.
Well,
Yep, everybody sign out.
Mr. Wood.
Oh, I'll just look forward to Gary Bloom and coming back someday.
Yeah, but I think we'll have him next month. Be careful, guys. Thanks for coming.
Mr. Grease.
We're adjourned. We're adjourned.
Nobody's gonna hear it.
I know.